felt that many listeners may not be very familiar with the intricacies of the Immigration and Nationality Act. The decisions which I've always made in the determination of the dates are based on the legally mandated guidelines in the INA, and they're not arbitrary decisions on my part. Although they do allow me to make discretionary decisions based on reasonable estimates, which I've always done, and typically in the applicant's favor. But once that I cannot legally make a decision once it is no longer reasonable to make estimates indicating, for example, that India would be entitled to using more numbers. But for example, last year, at the beginning, early in the year, I made the determination that the worldwide employment third preference number use would be insufficient to use all the numbers under the annual limit. At that point, I began advancing the India employment third preference and the China employment third preference states at a very rapid pace. And although the employment third preference limit for fiscal 2021 was approximately 5,200 numbers, the actions I took in advancing the India date allowed over 15,000 Indian employment third preference applicants to receive visas during fiscal 2021.
As late as August, you've been saying you did not expect any retrogression of fiscal year 2022 final action or application filing dates. Then during last month's YouTube event, you said that the potential retrogressions announced in the October bulletin were based on discussions with USCIS during their inventory. Shouldn't you have known about the inventory totals long ago?
Yes, the inventory totals for all the employment categories were known long ago. But it's important to remember the only retrogressions that have occurred are with the India and China employment third preference categories. But the no retrogression comments that I made earlier in the year had been based on the expectation that despite immigration doing their best to fully utilize numbers during fiscal 2021, that they wouldn't be able to sustain that level of effort as we entered fiscal 2022. But then in late August, early September, when I was discussing their staffing situation with USCIS officials, they indicated that they believed that their processing efforts would be able to be sustained at a very high level for the foreseeable future. And because of that, there are a lot of rest of world numbers, countries which have not fully utilized their employment third preference limitation could potentially need numbers. Therefore, it was necessary to impose both or retrogress the dates for both China and India to keep number use within the overall employment third preference limit.
Great, and I believe there is a PowerPoint.
Yeah, I've prepared a PowerPoint to help make it easier visually for people to understand the situation which is going to impact the fiscal 2022 employment-based numerical control issues. And the first slide will show the estimated fiscal 2022 employment limits for each preference category.
There we go.
Okay, that'll make it easier for everybody like me that needs glasses. So these are the estimated annual limits for each of the preference categories during using India as an example, since that is one of the countries where the final action date retrogressed for November. And this next slide, so you see that the limit for any country for the third preference would be 5,605. In October, we already had over 44,000 Indian applicants who had priority dates within the October final action dates. 5,600 versus the 44,000. This is why it was necessary to retrogress the India third preference final action date to control number use within the allowable annual limits based on the Immigration and Nationality Act guidelines. Then the next slide, this shows the amount of applicants. Again, I'm using China and India as examples, since those are the two countries which faced retrogressions for November. As you can see, the annual limit for fiscal 2021 was 18,360. China employment number use was in excess of 22,000, and India employment number use was in excess of 77,000. So this clearly shows that the actions taken were to maximize number use, not only within the worldwide limits, but within the China and in India employment limits. The next slide is going to show how we make a determination of otherwise unused numbers. The Immigration and Nationality Act allows us to make a decision at some point during the year that there may be otherwise unused numbers under the annual limit that we can provide to countries which have already reached their per country limit. So again, using the third preference example, the annual limit is 80,080 and the per country limit would be 5,605. Then the next slide, this shows that I can already know that both China and India will use all of the 5,605 numbers allowable under their limit. So I subtract those numbers from the 80,000 limit. At this time, I'm estimating that countries from all over the world will use an additional 55,000 numbers. Again, this is an estimate. So when I subtract out those three figures,
This had a wonderful show. A quick video from Charlie, and I guess we're sharing some bad news, more or less, with what's being predicted for the upcoming fiscal year with GCs. We were expecting, more of a positive outlook, but it seems to be, there's more bad news on the horizon. Now, having said that, we can expect, hopefully, here in the near future that USCIS will, again, start processing cases at a normal clip, and we'll be able to, utilize some of these unused visas and things like that to where everything will balance out again. There's still a lot of movement right now, and we're seeing this EB3 retrogression and EB2s, being more commonly available as far as the allocations go. And, like I was saying previously with FinCat, is we have to see how many people who have downgraded and receive a GC then have the other, I-140s accounted for, things like this. We have to let the dust settle, so to speak, before we see any real movement with these numbers. So I know it's a bit of a bad news and downer, moving forward right now, but I still think we still have some optimistic opportunities here that we can move on. And I have been speaking to a lot of clients and people who are not clients, and addressing issues as far as, maybe GC EAD delay, GC processing delay, H4 EAD, L2 EAD delay. And I think the one common theme that we're trying to get out to everyone in our community and everyone who's listening is that, you need to find out who your local congressperson is, reach out, and we need to really make a movement and get the needle to move with this to make sure all of our representatives know the issues we're having right now with these backlogs and these struggles that everyone's going through. We should not just accept it because that's the process or the way things have been done or are currently being done. We need to take action and, really reach out and let a lot of people know, this needs to be corrected. And right now, it's a prime opportunity because we have, certain bills, and that's also been a bit of a fluctuation with what we expect. Some weeks we say, this is going to be included in the bill, and then we hear the news and, this was negotiated out, and then now there's a possibility for it to be negotiated back in. Now is the prime opportunity for everyone to reach out and make sure you make a lot of noise with all of the Congress people that represent, everyone across America, and also senators. And we want to make sure that whatever is included in this new spending bill that gets included to help address these issues with immigration. And hopefully President Biden can sign this into law, here in the near future. Also, we want to touch base and just remind everyone that there was some news. I think a few people have also brought up and discussed it here in the past 2 weeks. DHS, Department of Homeland Security, has backed away from the enforcement provisions for large worksite raids. A lot of people say, oh, this is great. Now the government's not going to focus on, following up on my status or anything else. And actually, I think you can look at this in a bit different context where the government's not going to go and raid large complexes where undocumented employees are working. Rather, they're still going to turn their attention to, regular violations, within the context of maintaining compliance. So you might see an uptick in, maybe a certain FDNS site visits. You might see an uptick in maybe a Department of Labor investigations or audits. I think that we're going to see more of that as two things happen, both this newer processes and policy take effect, but also as we hopefully come to a close with this current pandemic. We want to, as things start moving back to normal, there's a lot of people who are going to continue working remotely. And a majority of our listeners, and majority of us still, have the option to work remotely at time to time. And, especially if you're not immigrant, DHS is going to have to figure out a way of how do we maintain and know the compliance regulations, site visits, things like this, and adapt to this new work environment, this new relationship that employers and employees have. So that's something that we're, keeping tabs on, and, moving forward. Hopefully, we have some more information about compliance and things like that. Additionally, I mentioned them earlier, we have been seeing quite a few delays for H4 EAD and L2 EAD processing. And I think Venkat and I both, speculated earlier this year on the show that we were expecting, hopefully things went back to normal. We can have faster processing times, primarily if you filed an H-1B extension or transfer, and you also applied for your spouse to, file with you, that things would go back to the way they used to be, where we would have approvals within 1 or 2 weeks of the principal H-1B being approved. Now, after May came and went, we saw that, this policy did not really impact anyone. removing biometrics. The delays are still there. If anything, the delays and the backlogs are getting longer. Our office, we've been filing hundreds of cases individually against the government, against USCIS and DHS for these delays. And these are often referred to, we refer to them as mandamus actions. There's basically something we've been using to help get these cases moving. And, we've been able to work with assistant U.S. attorneys around the United States. We've been filing from coast to coast, and we've been able to, on average, get H4 EADs approved within three and a half weeks after we file the case. So, we have that momentum. It's something that is often should be used as a last resort, and it's unfortunate. A lot of the needs, a lot of the issues we have today have come down to this, where we have to use this tool of last resort to use the courts to help interject and intervene in these cases. So other than that, I think, we're back to, I guess, more of a business as usual in the context of waiting. And it doesn't seem like much changes on the horizon, but, hopefully we can get these changes in policies updated, if not the law changed and updated as well. So that's something we're hoping for. And again, I'd like for everyone to reach out. If you need any assistance finding out who your congressperson is, finding out what to say, whom to speak with, who your senators are, let us know. Both Venkat and I would be more than happy to share that information to help everyone find their representative. You can also contact the American Telugu Association out of Washington, D.C. I think they have a formal process that they're encouraging people to go through as well. So maybe if you don't know exactly what to say, maybe they might have some language that you could use whenever you call and contact your representative directly. Other than that, I think, there's been a lot of confusion, a lot of questions also about the pending I-140s. I know last year we filed quite a few downgrades, and there's a lot of cases that are still pending. I know that a lot of people have been concerned to say, like, hey, I've had this case filed. My priority dates are moving. Let's go ahead and upgrade my case to premium. Maybe USCIS is not honoring the premium request. Maybe there's been a rejection, or they're just delaying the processing. I think that, as we go through and we see these challenges, it's also good to remember that, while that is still pending, it gives you multiple options of what you can do. So if your priority date becomes current EB2 and your EB3 downgrade is still pending, you can always pull that request and use the EB2 I-140. And I know a lot of people have been asking me, Lucas, what's going on with this current process? I hear from other people that maybe I should file a second adjustment of status, or I should do multiple things. And first and foremost, I want to go over the process with everyone and be very clear about what we can expect and what we should do, both on my role being an attorney, guiding you through this process, and you as a client expecting the benefit from the government. So what I can tell you is this: as an attorney, as a representative, I'm not only here to help provide you with the service to help facilitate obtaining a certain benefit or relief, whatever it might be, but I'm also here to help guide you through the process. Now, as an attorney, I should do so with your best interest in mind. I shouldn't ask you to do something out of the ordinary, or I should not ask you to do something that maybe is a duplicate of what we've already done. It's best to always stay the course with that, and work with your attorney. And as an attorney-client privilege is established, we should always have, somewhat of a teamwork mentality. It should not be my goal to lead you to do multiple things or to do multiple filings or things like this if it's unnecessary. I know some other people have requested to say, I heard from another podcast or WhatsApp group or whatever that this person said to go ahead and file one or two additional adjustment of statuses, one for this EB2, one for this EB3. And my answer has always been you shouldn't do that, in the sense that you should wait and see where we're at. And I know it's a little bit of extra work, but the attorney should be communicating with USCIS. It could be an interfile, could be whatever it might be, but your adjustment is a singular case, and you can move visa categories from one lane to another if you meet the requirements at that time. So if you have a case that's in EB3 and you already have an EB2 I-140, you can use either of those I-140s to process your adjustment of status. So basically, you're on the best way to think about this is you're on a route, and there's 2 lanes or 3 lanes that you can choose for that route. One lane might be faster than the other, but you're still going in one direction in one route. You're not multiplying those routes because that would not make sense. It's the same thing here. And that's why you should be cautious about doing this. If a lot of people start filing multiple I-45s and have multiple cases assigned, all it's going to do is slow down the process altogether. And I'll give you a good example of what this means. Every person who comes to the United States and wants to immigrate here is given an alien number. So this A number is much like a social security number. It's a 9-digit number, and it's assigned to you, and it's only you, and it's your only number that you're going to have. With your A number, you're going to have an A file. In your A file, you're going to have all the pertinent information that's regarded to you transitioning from a non-immigrant to an immigrant. So some people are assigned A numbers if they come into the country without permission, or they violate a term of their status and they're put into removal proceedings. They're going to be assigned an A number if they don't already have one. Okay, that A number is only one number. It's just like your social security. You're not going to have multiple social securities. All these numbers referenced go back to one file. Now, you say, well, what does this mean in the context of everything? When you mail in your adjustment of status application, it's going to be associated with your A number. And your application is going to go into a file. Now, USCIS still operates much like they have for the past 30 or 40 years where they use paper. Nothing's really done. Even if you file online, you're still at the end of the day going to have some type of paper file that they print out and store. The reason everything's done like this is your file is going to be transported maybe from a service center to a national benefit center. It could go to an immigration court, could go many different places, and your file is always going to be associated with that. So anything that ever happens, if you ever go to your interview for your adjustment of status, you'll notice the officer that's going to be there has your file with all your applications in there. And they're going to verify all the information in the file and then either sign it or whatever they're going to do. But all the information is in that file. So if you file multiple adjustment of status applications, you're only putting multiple applications in the same file. And in the context of processing everything, all this is going to do is delay processing or possibly confuse the officer of what's going on here. The proper way of doing this is whenever you have your A file, the officer is going to have all the I-140s associated with you because that's something you're going to be filing for to adjust your status or for an immigrant benefit. Now, they're also going to have record with your A number, which I-140 you filed and what the priority date is with that visa category. Okay, they're going to know you have two I-140s that have a certain priority date, and they're going to know based upon your A number, okay, this person's case is ready to proceed because the priority date is current in EB2 visa category based upon this country or this other category for whatever visa is allocated for. And based upon that, they'll start working on the file. There's no need to file multiple adjustments. And I know there's been a lot of confusion on that. I know a lot of people say, well, there's no rule or statement or regulation that says that you can't file multiple adjustments. But from my own experience and my knowledge, I mean, it's preferred to not do that. Another good example would be this. Some of our clients might go through removal proceedings where they might be here in the United States undocumented. Well, they'll go through the same process having an A file. Now, they'll say, this is person A, there's the fingerprints, here's the photographs and everything else to identify the person. And maybe that person's caught again and processed again, and they might give an alias or a fake name, and they'll be assigned a secondary A number. And then once they figure out and they run the biometrics and they know that person A and person B are the same person, then that person has two A numbers, which is something that has to be corrected. And anyway, with this example, what I'm trying to get to is you do not want to file multiple adjustments or anything like this, because all it's going to do is slow down. It's going to force the service, force the officer to reconcile the file. And all it's going to do at the end of the day is delay and cost money and waste time. And that's more or less our update so far this week. I'd like to maybe welcome Venkat back to the show with me and see if he has any comments or questions from our audience to see if there's anything we can address.
Yeah. Thank you, Lucas. Thank you very much for information. Yes, we do have a lot of questions as per yesterday Charlie video. It means most of the applicants got cleared on the next coming up visa bulletins about EB2 and EB3 and also about the visa numbers. So as we know from the Charlie video, around 280,000 visas coming up, maybe allocated for year 2022.
Mm-hmm.
So the point is EB3 is, I think, look like it's struck up, right? It retrograde back to January 2012, right? So even we observed from the video saying that the EB2 will not move until September 30 or something, this entire fiscal year, because have the enough demand from EB3. So the overall question here, when Charlie presented the graphical representation, most of the applicant got awareness of what is the allocation of how many numbers of it allocated to each category. So what do you think about this current situation, especially EB3? It means most of the applicants downgraded to EB2 to EB3. The still I-140s are still pending. We don't have any kind of information where we are, when will we get this, when we'll get approved I-140s. So most of the EB3 applicant in dilemma. So based on yesterday video, it clearly saying that maybe EB2 might move forward compared to EB3. So already you explained. Just to give me what is the state. Just to give me your insight based on. I will ask. I do have a couple of questions, and I might ask those questions.
So I think that's a good point, and I think it's good to remember. I know we speak about this some. Whenever you file, let's say I have been here since 2010. And I'm in H-1B status, and let's say in 2012, my employer filed for I-140. Okay, and I get it approved. My priority date is December 2012. I changed employers in 2016, and I ported my priority date from 2012 to them. So I have two EB2 I-140s. So I've been with the second employer for until now, and then I decided to downgrade so I can file for my adjustment of status. So now I have three I-140s. Well, when you look at the data, is that all of us can access, when you look at this for my priority date and December 2012, you're going to see three reserved I-140s for that time, two in EB2 and one in EB3. It's not going to be reconciled until what I get approved for my adjustment of status. Now, let's say it moves forward and I get my GC. Well, at that time, my A number is that's associated with all three of the I-140s they're going to know, okay, now Lucas has his GC, his A numbers 1, 2, 3, 4, 5, 6, 7, 8, 9. Any other I-140 associated with that, we know we can take off the board. Okay, so I think a disservice that was done last year was moving so many the dates so fast in EB3. I really think that caused an issue because USCIS wasn't prepared for the number of downgrades they came. And so right now we have all these cases pending, and we don't know if one of my I-140s that's in EB2, but if that priority date comes current and I get GC and I have a pending EB3 downgrade, well, they don't know, what's going to happen. And I think, reading between the tea leaves here, I think what you're looking at is they're saying, let's let things lie here. Let's continue pushing as many of these pending cases as possible, but they're focused more on, reconciling and letting the dust settle. I guess that's the best ability that I have for me to explain the scenario, but you really have to see, because right now there's so many filings, and that's why I just got through mentioning it. We do not want to be hasteful and file multiple cases. If you want to go to an attorney, there's some attorneys that will just take any money you want to give without second thought because they're in the business to make money, right? This is why I'm saying you have to, everyone should pause, wait and see. There's other avenues we have to address the situation. We need to address the whole overall backlog issue with government. We need to address that issue and try and fix it. We don't need to keep pushing more and more cases through the system, because all that's going to do is delay the processing for everyone. Okay. And we have to remember, every year these visas expire. If you're hastily filing as much as you can, as often as you can, all it's going to do is cause processing delays. And at the end of the day, you're potentially causing visas to be wasted. They could have been used for someone else. Okay.
Lucas, you mentioned a very interesting point here. We should not apply the multiple 485s, even though you have I-140 in EB2 or EB3. So here, it means, can we expect, as you said, right, it means already EB2 I-140 got approved, EB3 downgrade is still pending. Let's say we take the January 15, 2012, it still is not, it retrogression back. Let's say next couple of months in EB2, it go to the February 1st, 2012. So USCIS will process whoever their priority date January 15, 2012, even though
so it's
EB3 pending,
correct.
EB3 haven't pending?
Correct. And I want everyone to remember this. So in my example, I have my A number, 1, 2, 3, 4, 5, 6, 7, 8, 9. Every time I file I-140 or AOS or anything, my A number's with it. USCIS has record of knowing that okay, this I-140 has a priority date of this. It's associated with my A number. This I-140 I've filed with a different employer. It has the same A number. Maybe it has the same priority date if I've ported it correctly in this EB2 category. I also have another I-140. It's associated with my A number, and it's been filed in a different category, EB3. They have the data knowing that here's my AOS file, right? My A file, like we just went over. My A file has my A number. My A number is going to be associated with these other I-140s. There's 3 of them. And the priority date I have is this date. And the visa categories are as follows, EB2, EB3. Just because one of these dates or 2 of these dates or whatever might happen, it's still, I mean, it's all allocated through my A number and the priority date and the visa category. They have record of all this. So just because you have a downgrade and it's pending, they also know that you have an I-140, and if you're amending, like what we discussed many times, if you're amending the I-140, they know it's associated with the other EB2 I-140. So everything is there. Everything's on the table, organized for USCIS. They know these things. There's no purpose or reason to say I need to file another AOS with my I-140 for EB2. I mean, it's just a waste of time, resources, and money. And it shocks me to hear this crazy thinking, because that's not the correct way of doing this. You should. USCIS has a way of tracking these cases and knowing. Just because we don't have the knowledge, either for certain privacy reasons, I can't just access every single I-140 that's pending right now with your A number, with your name, with where you live. I mean, that's private information. But USCIS will have that information because they have to have that to proceed. And I know there's other people who've encouraged this thinking, and it's just to think that USCIS can't track an A number and what it's associated with is just bizarre to me. I don't understand that way of thinking.
Okay, so that is a good, I think it is a good information to know. But here the question is, the same scenario, USCIS, how well adjudicated the visa number from EB2 category or EB3 category? How it
visa is available. So every month we have the visa bulletin, right? And the visa bulletin is saying that these visas are allocated with this priority date. Once the final action date is current for whatever category, if it's current for both of your categories, obviously they're going to, use whichever one is processing first, probably EB2, I would imagine. But that's something that's going to be known by the officers that, Lucas with A number 1, 2, 3, 4, 5, 6, 7, 8, 9 as EB2 and EB3 pending with this priority date. Now, let me ask you this. What happens if my adjustment's pending in my current employer that has both the EB2 and I have a pending EB3 doesn't want to move forward with my filing, right? Well, I still have my EB2 from my previous employer. So that's still on the table that maybe they send me a supplement J for whomever I still want to proceed with, right? So I still have that ability under AC 21 to utilize that, port to another employer, or do whatever it might be needed.
I coming to the same question here. Yeah, now it means we process some current employer. Let's say once maybe get the GC EAD and I-140 approved on EB3, maybe the applicant decided to use the AC21 and change the employer. Okay, so in this case, in this scenario, the applicant is not on the previous employer, which he had the I-140s approved in previous employer. The current employer just he transferred based on the AC21. He had both the EB3 and EB2. Let's say EB3 still in retrogression and EB2 is an advanced. In this scenario, USCIS will educate this application 485 application, or still wait until it means he applied in EB3, so still it will USCIS will wait until EB3 get current.
So like I was saying, the filing date is what we utilize whenever we file downgrades. So my adjustment, and going back to using me as an example here, I file an adjustment based upon the filing date being current with my priority date. So I downgrade and file my adjustment of status with EB3. Now my downgrade, which 90% of the downgrades were filed as amendments, citing a previously approved EB2 I-140. So now I see both EB2 and EB3 are here with this adjustment of status, plus my A number might be referenced to whatever other EB2 has already been filed and approved with the original priority date that I ported over. USCIS has record of all of these because they're associated with my A number, much like your SSN with your credit report, right? It's always going to come back to you and only you. Now, USCIS is going to know that these are pending and this visa category is here and this visa category is here, okay? Once the priority date becomes, or the final action date becomes current with the priority date, it's going to be alerted to pull my A file and process my adjustment of status. Now, if they're processing my adjustment of status, let's say in November, and then in December, the date's retrogress, well, they'll take my file, they'll stop working on it, and they'll put it back on the shelf until the final action date becomes current again. So in the sense, you have to think of it this way, it's logistic in nature. You have one file with your application. It could be associated with maybe two visa categories, and whenever your final action date becomes current within this visa category, the officers are going to be notified that they have to pull this file and process and work on this case to issue a visa. Now, we're getting into this uncharted territory now where most people are confused because there's not much information on this, because the way the laws were written and the regulations were published, no one anticipated or expected these oddball scenarios to ever come up. No one ever anticipated we're going to have such a backlog of these visas that, you know, we're going to have to change the regulations and add on things with AC-21 for people to change their jobs because their GCs are pending for so long, or to extend their H-1 beyond 6 years. You know, when all this was created, none of these scenarios were planned for or even expected. And based upon, you know, a perfect storm of things happening, this is where it led us to today. And that's why I'm saying with confidence, there's ways of proceeding that the government's going to do, and we really have to be careful and more or less be responsible with how we proceed, because we do not want to cause any further delay. We do not want to delay anything to where we might risk a visa being lost because we get to September 30th of 2022 and that visa is unused. And then all it's doing is making the wait even that much longer for everyone who's not just equal in the same date with me, but people behind us, right?
Okay. It means whoever I-140 approved in EB2 and EB3, those can be benefited, right? Either at the final action date, USCIS will consider which one is the final action date, either EB2 or EB3 segment, right?
Correct. And I think one thing I want everyone to remember is whenever you filed your I-140 and then you downgrade, you have two cases, two I-140s. It's the same petitioner, right?
Yeah. So it means just you mentioned the amendment. If we do the amendment to downgrade EB3, the still EB2 is exist, right?
So that's what they're doing right now. That's why we're seeing everything in pause. I think they're waiting to see which visa category is going to come up. That's why the I-140s are still pending in EB3. And I think that's why a lot of people who've tried to upgrade have had issues. And I think, you know, USCIS has done planning, and I think that's why they've coordinated, with the State Department and seeing how they're going to process and proceed with these visas. And I think there's going to be an opportunity here for a lot of these cases to be processed, probably at EB2, even though you were able to file in EB3. And going back to what I say, it's so important, is the more we push and rush and try and get everything moving, sometimes, it can slow everything down. I've often been told, growing up, I was told by my dad, sometimes to go faster, you have to, proceed slower. And
here also one is the interesting point is you mentioned that the employment GC for employment 480 process is a lanes, right? EB1, EB2, and EB3. Let's say we consider as a 3 lanes, right?
Yep.
So here we need to choose, maybe we whoever eligible the particular lane, they can travel that lane, right?
Correct. So let's say.
So here the question is, let's say if any applicant apply 485 process in current employer, after that he moved to the another employer with the AC21, still the same lane applicant, the formula will apply?
Well, so that's the one thing we're still, I think we could make an argument for that to happen. Now, technically, the former employer, if it's a pending I-140, they could always withdraw it, right? And so your portability can be limited that way. But just, I think the best way of explaining this is, I think there's a way, the way that the purpose of these regulations of portability and everything else is to give is for the employee to have rights. Okay, we do not want an employee to feel trapped or that they have to stay somewhere or they can't move or advance their career. So even though it's something that's not fully known at the time, I think there's a lot of opportunities for an attorney or whomever it might be to really make a good argument to address that issue. So if someone's struggling with that right now, I think that there's an opportunity we could have to address that, whether it be through the AAO, whether it be through the U.S. District Court, or whatever it might be. I think that there's kind of a gray area here, if that answers the question.
Yeah. Here also, based on the scenario, I have one question. Let's say one applicant had the 2 I-140s, the current employer in EB2 and EB3. So after maybe 6 months or 1 year, he moved to another company based on AC21. That previous employer, due to it means he revoked all I-140s, EB3 and EB3 due to some other reason. But at the time of 485 adjudication, will we see any issues or something? What is your?
Well, yeah, if you have to have an I-140 approved. So the most common thing for, let's not use the revoke scenario, because typically if you downgraded, your EB2 is more than 6 months old and the employer can't revoke. So let's change examples here and say, let's say you work for a consulting company and this consulting company did borderline unethical things and they got in trouble, even if you didn't know about it, and your I-140 was found to be revoked because of misinformation or misstatement of material fact or something like this. And so now you're sitting here and your I-140 has been revoked. Can I still proceed with adjustment of status? The answer is no. You have to always have that adjustment or the I-140 pending or being approved, because as soon as that's taken away or withdrawn or denied or revoked, whatever it is, the adjustment application also goes with it. So they're mutually tied together.
Okay, it means both I-140s, EB3, EB2 should be active until 485 adjudicated, right?
The EB2 would have to be what you call active, because if it's more than 6 months, the
Okay.
employer can't revoke. Now, if the EB2 dates became current, and let's say the EB3 is no longer needed or required, I mean, you could always port that over, because you're going to need to have a supplement J to be forwarded to show that that job is still available. Now, if you have to have a supplement J and you're not with that employer anymore, you can port that to another employer as long as the job duties are the same or similar.
Okay. So I do have one question on I-140s. What is your suggestion to do premium process on I-140, EB3 downgrade I-140? Let's say if any applicant want to use the GCEAD, so you want to use the GCEAD, you want to start the premium process. What is your suggestion on this?
I mean, like what we said in the show, everyone, as a general rule, I would say just wait. Let's see where we're at. But as an attorney, I have to tell people, like, you know, all these statements we're making, you and I are discussing here, are very broad and generic in general. We're talking about policy, we're talking about procedures in that sense. You should always, and I'm always open to talking to anyone who's watching our show, anyone who wants to discuss their situation, I'm more than open to do that. Or if you want to discuss it here on the show, you're more than welcome to participate. You know, these are very detailed or evidentiary specific statements we're making, right? So what might be a good idea for person A might not be a good idea for person B. And I think it's we always have to pause and make sure that you're consulting with either your attorney, or if you talk to me, make sure you give me the details specific to you, because to give a generic answer to that question could be beneficial to one person and devastating to another. Okay. There's a lot of things we as attorneys have to do to make sure we're prioritizing your case individually, that we're not overlooking anything, that we're giving you the best advice and the best decision making that you can have, in your hands for your own self, your own case, your family, everything else.
Okay. I have another question on the same scenario for EB2 and EB3. EB3 maybe priority date and current, and is EB3 still in retrograde? So in this scenario, if any downgraded 485 adjustment status, let's say the USCS may be consolidated, and whichever is priority date, maybe they can adjudicate it. In this process, should we submit any form or something, or just automatically USCS will take the case and check the all I-140s, and they found EB2 I-140 is a current, maybe based on that they can adjudicate it?
So that's a good question. The typical practice for this is usually in a family-based context, right? So we have two different processing types. You have family-based petitions, employment-based petitions. They don't interact with each other in the sense of priority dates or anything else, but you have two different immigrant processing systems here. So we see this often in family-based petitions, where maybe you have a brother or sister who's a U.S. citizen who sponsors you, and then they also sponsor your parents. Well, the visa is going to be available for your parents much faster than it would be for yourself, because a parent is an immediate relative. So once the parent becomes, let's say, a citizen within 5 years of getting their GC, and your brother or sister who's a U.S. citizen has that petition that's there with you, well, instead of waiting 15 years, maybe on average, for the visa to become current, the final action date to become current for that category, your parent can now file for you with a different I-130, and you can utilize that priority date. And if and start the process that way. So if the priority date is there and it's averaging 5 or 6 years for, whatever it is, you can move and sort through, the visa categories that way. You could do the same thing on employment-based side. Now, we haven't seen it historically as used as often because usually for employment-based visas, we see, not such a backlog existing. So we don't have to, maybe think I'm going to file both EB2 and EB3 or anything like that. So in the context of what your question is, whenever we do something like this, you can always send a letter to USCIS, like an inner file or whatever you want to call it. And basically, it's going back to the same thing I said before. Whenever you file something, there's going to be a file, a physical file with everything inside for your case. And whenever, USCIS should know, associated with your A number, you have these pending petitions or approved petitions with a priority date of X, and that you have visa categories A and B. Okay. Now, it doesn't hurt for the attorney or you or whomever to send in a letter saying, hey, don't forget, I also have, instead of just EB3, I have an EB2 and things like that. And they'll, take that and pull the file, make sure they put everything inside the file and put it back. That's, something that we can all proactively do. And whenever your final action date is going to become current.
Okay. So whatever we discuss about this 485, maybe as for this today conversation, if one single 485 we can utilize whichever I-140 priority date come over. So do you have this information from USCIS website so that everyone get more information and maybe they can educate?
I don't know off the top of my head where you could find this. I just know you could probably search the regulations to see this, or the officer's adjudication manual or handbook. They'll have some steps and procedures in there that way. But in the sense of just working with USCIS and being to numerous interviews, being to immigration court many hundreds and thousands of times, I mean, I can just tell you that the way the government works. So whenever I go to, let's say, a visa interview, every time we go, this A file is going to come from the National Benefits Center or Service Center, whatever it's going to be coming from. It's going to go physically to the field office. So they're going to pull a file. This file is going to have all the petitions, adjustment of status, whatever it might be, is going to be associated with this one file. It's going to have an A number on it. You open the file, it's going to have the photos stapled inside. It's going to have the medicals, whatever it is, it's going to be organized and then sent to the field office for an interview. They do the interview. They literally, obviously they've suspended interviews now, but when that goes through the interview process, the officer is going to look to make sure the file's complete, all the information is correct. There's going to be some questions asked, and they will sign the application. It's still in a file. Then the file is going to go to their supervisor for signature. And then once that's done, it'll go back for further processing to issue the GC. And then everything's closed and it's moved on. So, I mean, that's just if you think logistically, that's just how things work.
Okay. So what is your suggestion about what we discussed, 485, if any EB2 dates are move forward, if any downgrade person want to utilize the EB3, the particular, maybe their attorney came and hey, you want to apply the another 485, utilize the EB2 benefit. So what is your suggestion to the applicant? How they want to, it means, what is your suggestion? So,
I mean, I would proceed with caution, and I would want to know, you just asked me to explain it on the website where we can find the information. Well, I would ask that attorney who's asking me to pay more money, because I doubt they're doing it for free, Show me where it says to file multiple applications with different visa categories. Show me where it says to do this. And there's other people who've been on, posting things online that's very disingenuous. Okay. There's a lot of people who are suffering right now. There's a lot of people who've been frustrated, who have invested a lot of time, invested a lot of money, and invested their career to be in the United States. And it's very disingenuous to, without any citation or any knowledge of how things work, to encourage people to file multiple adjustments, because I guarantee you, I doubt this other attorney you're asking about, I doubt they're going to file your case again for free. Okay. And I'm sure they know better. And like I said, if you file your adjustment, all that paperwork is in your A file. If you have any doubt as to what's going on with your A file, and if you want to make sure that that priority date in this visa category, now in EB2, is addressed correctly, have the attorney write a letter saying, hey, we filed this adjustment of status on this date. The case number is this. The alien number for the beneficiary or the applicant is this. They also have a previously approved I-140 with a priority date of this. And in fact, this other I-140 was downgraded to EB3. We would now like to consider this other I-140 and EB2 to be used. It's a one-page letter that takes care of this. And that's probably more efficient than refiling all these adjustments, because all that's going to do is, and I want you to remember this. I'm going to ask you, Venkat, real quick. How long did it take last year for us to get receipts for downgrades in general for our listeners?
It took a pretty long time, actually.
Correct, because there was 100,000 extra applications that were sent in the month of October, correct?
Yeah. Still, it means I observed most of the maybe 40 to 50% applicant who applied at Texas Service Center. Still, they did not get the biometric. So,
and it's a huge caseload. So why, if everything's still pending and everything's slow processing and everything's overburdened, why in the world would we want to add more instability to the system that's already there? Why? What does this do when all we have to? I mean, at the end of the day, the new application's still going to go to the old folder, and it's still going to go back in another A file, and then there's going to be confusion by the officers. Why is this here again? Okay, you should. The correct thing to do would be if the person, and I recommend this for all my clients, if your priority date it comes current in either category, you need to reach out to your local representative and your senators to say, hey, look, this is very important to me. I've been here this long. My kid's a U.S. citizen, possibly. My spouse is here. We want to be permanent residents and eventually citizens. It's very important for us. That's number one. You do that, they help push USCIS to get the case moving. Number two, if it comes up like this, attorney can always write a letter and say, look, the priority date in this category is now current. We want to consider this pending adjustment of status under this category. And that's just to help notify USCIS, hey, we don't forget there's also another I-140 here that we would like to use with this and change visa categories. If you file another adjustment of status, you're increasing all this process going through. And then when it comes time where they're, maybe they make duplicate folders, maybe there's an issue where they're confused and things get lost, or if at the minimum, it's just going to slow down the processing, right?
Yeah. So we have a question on YouTube. Just, I think V. Lakshmi is asking, after retrogression, recently we see the EB3 retrogression, right? USCIS will process I-485 based on the received data or priority data?
Priority date. That's
Priority
a good
date.
question. So if your final action date is current with your priority date, then that's triggering USCIS to continue processing the case. And just to remember with these A files, and this is just an envelope, but whenever you have your A file, USCIS has barcodes and everything else to associate with that. And as soon as these come up, they know, okay, there's workers that actually literally go and they'll check out the files, pull the files out, forward the files to wherever officers adjudicating them. And, usually this is done and they're notified as the visa bulletin's published. And, it doesn't hurt for us to maybe reach out and like I said, follow the steps we just discussed. But yeah, definitely that's what we want to do moving forward.
Yeah. Lucas, last question, the same topic is 485 EB3 and EB2 categories. Do you see the term is interfile, 485 kind of interfile, EB3 to EB2, or? I
think it's just like if, the term, there's a lot of people that use the term interfile. I think that all we're trying to do is just, send a letter in notifying USCIS saying, applicant Lucas Garritson, alien number 123456789, has a pending adjustment of status application, SRC 21, whatever it is. He has a pending EB3 I-140 case. This is the case number, and he has an already approved I-140 EB2 with the same petitioner.
It means this is kind of a notifying to the USCIS, right? As you say, right?
It's just notifying, and it's just basically so.
Is any form from the USCIS? Hey, is a 485 interfile form or something? Did you see anything? Or
it's not a form. It's just basically updating and notifying the officer that or whoever receives the case, like, hey, pull this file, make sure we're associating these cases with this I-140 that was filed on this date and everything else, because everything's going to be in the same. It's just like this. If you have your I-140 in any immigrant-related petition or application, it's going to go in a file. Now you have to ask yourself, well, how does USCIS manage all this stuff if everything's on a file and it goes in a file cabinet and a big filing facility? How do they know which files to pull? How do they know where? I mean, just think logically here. They're going to have a database. They're going to know this A number that I have is associated also with these other I-140s. Okay. They're going to know automatically, okay, priority date for all these people have now become current. Let's pull these files, okay, and send them to the officer for further adjudication. That's the way the system works. That's why I'm trying to say there's a method to the madness, so to speak, with how this works. So if I send in a letter and I'm making sure that, hey, put this letter in the file, pull the file because this is priority date, it's just verifying that to let them know that these cases are related, that the priority dates are this, and so on and so forth. But USCIS has their own system to know when a case is filed, what the priority date is, what the visa categories are, and move about it that way.
Yeah, I understand. Today it means whatever I ask the question, maybe the all question is related to the same topic, but it means it is a very confusing environment it means today is a very interesting point. You saying that we can apply only the one single 485 and we can utilize both the categories, maybe whichever come through first. So that's why I asked this. Maybe kind of questions all are related to this 485 adjudicated process. So Lucas, really today's session is very informative and is a very good session to get knowledge on about the 485 process. The most of the applicant EB3 already thinking negatively. It means it based on the retrogression, it all are stuck up in EB3. Even spillovers, right? Spillovers, it will come from EB1 if EB1 left and EB2 and the EB2 left and EB3, right? Well, is the least category in EB3. So it means every applicant who are in EB3 definitely think this way. So as today session maybe might get some information, maybe they can research on this topic and get more information, really good information today. Yes, Lucas, you can.
I mean, I want to remind everyone too that if you have a pending downgrade or something like this, I mean, you still have the EB2, and if the EB2 is going to advance and move faster, I mean, just think rationally for a minute. If the average person who's being processed for GC, based on my experience, this is the truth. The average person is going to have 3 I-140s, 2 EB2s, and 1 EB3 downgrade pending. That's how is anyone going to actively know what's the future is going to hold? Because until that person gets the GC, no one knows. You can't take off the other I-140s off the table because the applicant still has the ability to use whichever one they need. Now, once the applicant gets their GC, USCIS is removing 3 I-140s off the table. So you have to think of it in multiples. You have to see, okay, the EB3 is retrogressed probably because they're trying to, look and see how many EB2s they can move. And this time last year, or from, I guess it's already about a year now, the final action date for EB2 was May 2009. Look how far that's gone in 1 year. I still think that we're going to see movement. And that's why I'm strongly encouraging everyone. Please, please, please. It is just as if you had cancer. I know it's a bizarre comment. If you have cancer and the doctor says, I need to take off your arm because it has cancer, you probably are going to go and ask another doctor their opinion before you have your arm cut off, right? You're not just going to rely on the statements of one person because it's vague and you're not going to take it at face value because of what was said just specifically just in this one scenario. You should try and maybe go and research, like what Venkat said, use information if it's from me or from someone else to verify it. Obviously, I would expect my clients to do the same thing to me. If I say something to them that's something that caught them off guard or doesn't seem right, I mean, obviously get a secondary opinion. I mean, there's a lot of money and time and lives at stake here. We don't want people to just listen to one person that's saying something that's unreliable and rely on that. That. It's just best to get as much information as you can.
Yeah. And before closing, we got one question on YouTube.
Sure.
Does the process you describe about linking of case with the A number apply to downgrade file as a new petition and not as an amendment?
Are you there? I'm sorry, yeah. My phone. So is it applied to a new petition or an amendment?
Yeah, the question is, does the process you describe about linking of case with the A number apply to downgrade filled as a new petition and not an amendment?
It applies to everything. I see what you're saying. So every time you file a case, everything that's associated is going to go and reference your A number. So let me just go to this. Say, hey, Lucas, I filed my I-140 years ago. My A number was this, but I moved companies and another attorney filed, and for whatever reason, it doesn't have they didn't include the A number. Well, based on my biometrics, based on other things, USCIS is going to know that here's this one file, and it's going to be one A file, one alien file. Anything that you do associated with that one alien file is going to be there until you become a legal permanent resident. And I mean, I don't know if any easier way to say it. I mean, if you think about it in terms of database organization and things like this, it makes sense. You have one identifier. Your identifier is going to be your A number. Okay. anything that happens within that account or within anything associated with that A number is going to be logged as a reference to that. So it doesn't matter if there's a new tag that comes up or if it's an old tag, everything's still associated and comes back in the hierarchy of a database. Coming back is the main key identifier is your A number. It's more or less the same thing. It's a certain filing system in hierarchy.
Yeah. Thank you, Lucas. We can cover the same topic maybe next couple of weeks, or we can educate more information on this one. This is the new topic and new interesting point you brought up today. So we can cover the same topic next week or maybe next following weeks to get everyone understand. So I think we more of almost 7:24 p.m. here. So
well, I appreciate the time. And, I get excited about this, but I do, if you don't mind, I'll close on this note. I really want to encourage all of our listeners to share the information. I know everyone is so eager to get to the finish line, to have the GC in hand, that Venkat and I at Telugu NRI Radio, we want to be a resource to help you make the right decisions, to be able to answer your questions, to be able to assist you through this process. And the way that works is you're always welcome to reach out to us through the show, to send in questions before the next show. If you want a topic discussed, or if you want to consult with us one-on-one, we're always here for that. We want to make sure that our community has the correct information, that is not taken advantage of, and that everyone can, get to the goal that they have, of whether it be to have a permanent residency, to maybe proceed with citizenship, whatever it might be. We want to make sure people are taken care of. We don't want irrational behavior to take precedence and for people to take advantage of people's eagerness to move forward through this process, because it's a very frustrating process, and we know it's a lot of people have been planning on this for many, many years.
Yeah. So we can close show today, Lucas. Thank you very much. You spent a lot of time today, and we can continue this show next week and same time and same platform. Wednesday at 6 p.m. We will see on Wednesday 6 p.m. Central Time. Thank you very much. See you. Bye bye.